Daily list for admission, item 1.
Lordship, before the item 1 is taken up, though yesterday we have fixed
Yes.
item number 4, it will take some time, I think. Since I have one committee to attend,
Okay.
Lordship, the matter may be taken up next week.
Yes.
In the meantime, my lord, I am for the respondent numbers. Okay.
4.
You are for the respondent.
I'm for respondent 5 in item 4.
Yes. I was just thinking, I just went through the file a bit. How about, okay, we'll, by fixing another date, how about putting the matter for final hearing and disposal?
Yes. It has to be finally heard and disposed
You have
of.
an interim order also.
Yes,
I
we
found.
have an interim order.
So, without taking much time,
Yes,
in the coming days, if we
that will
fix
be
it
in the interest
and
of,
dispose of the matter altogether.
yeah, in the interest of
What do you say?
justice.
Well, if it's possible, I would like to think of today, but since otherwise on Tuesday, my lord.
Well, I'll leave it to both of you, senior counsel and you. Work out a date and then fix it.
Tuesday, if I do, yeah, Wednesday.
Otherwise, the interlocutory application can also be taken up, but there is already an interim stay. Because the only thing that whatever I have, if I've understood correctly, what the thing is that the petitioner, learned counsel are submitting that they're seeking another route, that seeking interference with this judgment on the allegation of it having been obtained by fraud. Now we have to see what are the materials in support of that contention.
Yes, that's
If those materials
we have to prove that there is a fraud.
if those materials are sufficient to convince the court, then there was indeed some fraud, then perhaps something might be able to do. Otherwise, suppose the materials are of such a nature that the fraud aspect cannot be determined without evidence, then we fail as a writ court, isn't it? Then he might have to file a suit for setting aside a decree supposedly obtained by fraud. So whatever it is, I thought that one option would be to take up the matter and instead of the IA, take up the matter, WPC, and hear it and dispose it off. So, okay, you prefer that option to hear and dispose it off?
Yes.
So we'll fix it on, you suggest a date. You can suggest a date as per your mutual convenience.
Lordship, it may be taken up on, if possible, 28,
Heard
29.
27th, my lord, if possible.
No, I have no problem. You just work it. I can any of those dates is okay for me. Just heard learned
27th
senior
you do
counsel
me.
and so
I
for
think
the for the
Let it
petitioner
be on 27.
and can be who seeks some accommodation on the matter as he is having to attend to some meetings today. Full stop. It is also submitted by both the learned counsels. By the learned counsels on both the sides that perhaps an attempt can be made to hear and dispose of the main matter, WPC so and so, altogether. Full stop. List the matter on 27.
Yes.
On 27/2. 27/1/2026. In the IA, ma'am, there's a interim order by date so and so stands extended till the next date of listing. That will be the best course of action.
Yes.
You do it. The generally REIT does not. We all know that REIT does not lie against judicial order because always 227 is there. The parallel remedies appeal is there. But here, the fraud aspect has been, contended. So that has to be seen. And is it possible to determine that in a REIT petition?
No, my lord.
And if it requires evidence, so those are the issues. Anyway, that's fine. 27.
No place.
Item 1 for admission.
Lordship, I am for respondent 1 to 5 and I have already filed my affidavit in opposition.
Yes.
I am for respondent number 6. I may be given 3 weeks' time for filing my affidavit. I already received instruction and I forwarded my drafted affidavit for vetting, my lord.
That's fine, but his
I have no
contention
objection.
is that, you kindly show, identify, maybe for the next
Yes,
step,
yes.
identify the materials from the state respondents to show that he contends that the reduction is below 53%. The stipulated 53%. There's a 53%, the amount was reduced, right? That is the case, is something on those lines. The amount of the contract was reduced. And it was stipulated at 53%. He's saying that it is below 53%. And therefore he seeks interference, say 48% he says. So kindly see the materials from the state respondent side. So otherwise, you take your time. Learned government advocate Hertz and so on that submits that affidavit in opposition has already been filed on behalf of respondent number 1 to 5 / the state respondents. Full stop. It's so and so learned counsel appearing for
Respondent number 6.
respondent number 6, 1 to 5. Respondent number 6, 2 weeks time.
6 only.
6, yeah. And how much time you want, man?
3 weeks may be given, my lord.
3 weeks time to file its affidavit. Full stop. 6 in total, 6 respondents have been impleaded in the writ petition. Full stop. The union may file its affidavit in the meantime. List the matter on
19-2.
Lordship, in the meantime, we may be allowed to file a reply affidavit after
Yes.
receipt of the affidavit of the
in the
respondent
meantime.
number 6.
In the meantime, by way of exchanging further pleadings, the petitioner side is at liberty to file its affidavit in reply.
Authorized.
Item 2.
Lordship, I am appearing on behalf of respondents 1 to 9. I have received a copy of the Paraguay's comments. However, some of the annexures are not legible.
Just a minute, I'll come to that.
If I may take your lordship to page number 101, Annexure 21.
Some verification was done on the ground. Was some verification done on the ground?
My lord, if I might take your lordships to page number 101. Page number 101, Annexure 21.
Yes, this judgment.
Yes, this judgment, WPC number 124, 2023. Now, our lands are also situated similarly with the lands of the petitioners herein. The only difference is that the petitioners in WPC number 124 of 2023 was LSC, Land Settlement Certificate, whereas in my case, in the present petition, the lands of the petitioners are periodic pata. That is only the difference. So, my lord,
That is the only difference.
yes,
You relied on some case laws also, right?
My
About
lord.
entitlement or otherwise of the periodic patta
my lord.
petitioners. Anyway,
And we have also placed some judgments passed by this honorable court wherein the land value
That's it.
in respect of, yes, periodic pata has been given.
respondents 1, 2, 3. You are representing
Respondents 1 to 9.
1 to 9. All respondents.
All respondents,
All
state
respondents.
respondents.
Affidavit has not been filed.
Yes, my lord.
Affidavit, you are filing the affidavit.
I will be filing, my lord.
And look into that aspect also, that whether they are covered by any
Yes, my
judgment. In that case, we can dispose it off on those lines. Otherwise, if it is different, then we have to look at it differently. Learned government advocate, representing all the 9 respondents, submits that Paraguay's comments have been received, right?
Yes, however, the annexures are not legible.
Paraguay's comments have been received, but the affidavit proposed to be filed is not yet ready and seeks some time for the same. Prayer is allowed. And another thing, you said that you have some copies of the writ petition
Lordship,
are not
annexures
legible,
are
you said.
annexures of the
Writ petition.
affidavit.
Oh,
Paraguay's comments.
Paraguay's. So that's okay, you sort it out with the department. if and when, if the state respondents file their affidavit, the petitioner side will be at liberty to file its reply affidavit in the meantime. That will save time. This is the matter on. How many, how long?
After 2 weeks. my lord.
Take 3 weeks. That would be better. Is it?
My lord, it has been pending since
Okay, you want, no, 2 weeks.
10-2.
9th, what if you have to file a reply or something?
I'm
2
applying.
weeks.
Oh, pleasure.
You given the date, right?
10-2.
10 to.
Item 3.
My lord, state respondent 1 to 3, we have filed our affidavit this morning.
And my lord, I'm here for the respondents 6 to 17, and we have filed our affidavit in opposition this morning.
Your Lordship, I'm appearing on behalf of my senior for respondent number 4 and 5, my lord. So, my lord, if we may be given a week's time, my lord, to file our affidavit in opposition.
You are for the private respondents?
No, my lord, I'm for the MPSC, respondent number 4 and 5.
4 and 5.
Public Service Commission.
Public Service Commission. You agree by allowing supposedly non-qualified?
Yes, Your Worship.
Anyways.
In terms of the recruitment rules.
So can you just kindly repeat that? You are, Madam Additional Advocate General, Madam, you filed the affidavit? No.
I have filed this morning.
You filed, Lord
1 to 3. Yeah.
Additional AG, so and so, submits that the affidavit on behalf of
State respondent 1 to 3.
state respondent number 1, 2, 3 / state respondents have been filed today morning. You are representing all the
Private respondents 6 to 17, my lord.
6 to 17. Who's representing 18 and 19? You are,
Your Lordship, I'm appearing on
you-
behalf of my senior HMS.
no issues now. 18 and 19, right? Learned counsels also appearing on behalf of 6 to 17, respond number 6 to 17, within bracket private respondents. You have not filed, no? You see, there submits that their affidavit has also been filed this morning. Learned counsel appearing on behalf of respond number 18 and 19 private respondents. What is the submission you filed, or you are seeking some time?
I will not be filing.
You have not yet filed?
They're not going to file here.
They are not going to file.
We shall not file.
Okay, submits that these two respondents shall not file the affidavit. Learned counsel appearing on behalf of respond number 4 and 5 within bracket Mizoram Public Service Commission. 6, you seek some time?
Yes, my lord, a week's time. my
Week's
lord.
time, 6 a week's time to file its affidavit. The prayer is allowed. The remaining affidavits in opposition, if as indicated, shall be filed within this period. Whereafter, the petitioner side will be at liberty to file its reply affidavit if any. List after a week?
After we.
I think, anyway.
A date may kindly be given you.
3-2.
3.
I'm obliged.
Hearing list. Item 10.
Can you call that person? This was slightly too high for me. I need to reduce it. Can you give me a list?
My Lord,
Any other hearing matter today apart from this? Oh, no, okay. No, no, take it up.
My Lord, before I proceed with the argument, I would like to make one prayer. Your Lordship, initially the appeal was filed against the R1, respondent number 1, 2, and 3. Respondent number 1 and 2 are the claimants in the MSCT case.
And
Respondent number 3 is the owner of the accident vehicle. So, after filing the appeal, steps were taken as per the direction of this honorable court for service of notice upon the respondent. However, service of notice in respect of respondent number 3 cannot be returned after around 7 consecutive court dates. And as such, the respondent number 3 was strike out from the parties. But on perusal, careful perusal, and of the record, it appears that the respondent number 3 is a necessary party, because there are some, especially the permit. There is no permit, a valid permit in the accident vehicle.
Just a minute. Just a bit too high for me. How do I adjust this? Okay, better. Yes.
So,
Thank you.
in this regard, I would like to request this honorable court to implead again
Implead.
that respondent number 3.
You are for the claimant, right? 1 and 2. Now, if you are it all, whether the driver would, the owner would be a necessary party in a MAC appeal would depend on what is the nature of the challenge. If you are challenging the validity of the policy or permit or whatever, then and if it is upheld, then the burden of paying would fall on the owner.
Yes.
Therefore, in such situation, he will definitely be a necessary party.
Yes.
Otherwise, that judgment will be liable to be again set aside if he goes. So we cannot proceed with the hearing.
Yes.
Anything from my side?
I am not sure if any allegations have been made if any pleadings have been made in that regard.
I don't know because I have not.
Pleadings were made in this regard, Your Lordship. Even in the trial court and even in this appeal.
Where is he located, Mr. Mamid residence? Mamid district.
Mamid district. Yes,
Mamid district. Mr. So and so. She can take it. Oh, you want him to take it? Dictation? Huh? Oh, nice. The learned counsel for the appellant insurance company submits that when repetitive steps of notice upon the respondent number 3, the owner of the offending vehicle, failed, his name was struck off as being, his name was struck off, full stop. Struck off by order dated, can you help me with that?
24/7/25.
24/7/2025. Let me have a look at the order. In the cause title, it has not been, touched actually. We have not made the correction. It's not indicated actually. So we have to make that indication. Struck off, and again he has to be impleaded. You will implead it by, you write by hand? File fresh. Anymore. Right order dated 24/7, you write that. It is submitted by the learned counsel for the appellant that in the meantime, after going through the impugned judgment, he is of the opinion that perhaps the owner might be a necessary party for proper adjudication, for proper and effective adjudication of this appeal. Full stop. Also heard learned counsel, so representing respondent number 1 and 2, who were the claimants before the tribunal. Would you file an IA in that case? Usually implement is yes, because principal seat usually it is you have no objection to the implement. But
if you can allow by this court also, without the necessity of filing an IA.
The learned counsel for the respondent number 2 fairly submits that he has no, ideally it should be through an IA. He has no objection to the implement of the said respondent and the said owner as a respondent again in this appeal. I've given my consideration to the matter. and I find no reason to disallow the same, as the presence of the owner of the offending vehicle could assist in better and effective adjudication, effective disposal of the appeal. Full stop. In such view of the matter, the so and so, being the owner of the offending vehicle, alleged offending vehicle, is hereby again impleaded as respondent number 3. You will file a fresh sheet of the cause title.
Yes, Your Honor.
You have to
Yes.
file that. The petitioner, the appellant shall file the necessary sheets incorporating, making changes in the cause title, and furnish copies to the other side as well. The TCR is available.
Yes, Your Lordship.
Paper book has also
Paper
been
book also.
prepared.
The TCR is available.
Yes, Lordship.
The TCR has already been received and shall remain tagged with the case record. Okay. The appellant shall take steps upon the respondent number, the newly implemented respondent number 3, by speed post. Can you serve by Dusty also? Try to serve by Dusty. You take by speed post initially.
Yes.
List the matter in the orders column on. It will be in the orders or remain in hearing only. Orders column. Orders column on. You have to give some time since. In the meantime, you file this.
Yes.
You know that
the
cause
copy.
title.
Yes.
Cause title. Yeah, it can be. Do one thing. You will be taking steps also, right?
Yes.
Better. At least 3 weeks will be necessary. 3 weeks. After 3 weeks, on so and so.
Thank you, Lordship.
17.2.
Follow these modes. Speed post, if
Yes.
necessary, Dusty. Otherwise, go for paper publication.
Yes.
Paper publication. If not now.
Yes, yes.
If it fails again. So I'll see you next time. Like, sure.